bureaucrats, technocrats. I mean, you can speak to whether or not it was appropriate or inappropriate for that to occur. Would you have done that as a permanent secretary?
Politicians get the information from wherever source that they can.
That's going to be the extent of your answer.
Yeah.
Don't go there.
There's a lot of noise around the data protection bill that, in my respectful view, is not warranted.
I was one of those making noise, and it's simply because I was concerned about that specific section 33.
Don't go there.
Are you going to be offering yourself up as political leader of the party?
I see you've called me here for much more than diplomatic passports. I don't mind that.
Don't go there.
What is the relationship like between you and your leader, Dr. Mitchell, your boss, Dr. Mitchell?
I'm not sure how to explain how to answer this question at this time. I prefer not to answer.
Don't go there.
They said that you approached the bank for the loan before the election and that it only materialized after the election. There are also conflicting reports around the quantity of monies that were received. What is the reality here?
People try to extort the truth and to make all kinds of things about it. I just stay quiet. So if you notice, I was really and truly quiet about the whole matter.
Well, except with not with the New Today newspaper. The New Today newspaper reported on this, so I'm not sure you were quiet on this. Go ahead, Honorable. Go ahead.
Well, I'm just trying to answer your question, right?
Don't go there.
I think we just spoke at length about the regularization framework. So
yes, we did. But let us talk, Prime Minister. Let us talk about the workers who are dismissed.
The Bob Report. We go there.
And viewers and listeners, welcome to yet another edition of the Bob Report. I am your humble host, Dr. Kellen Bob. We are happy that you can join us today. Of course, as you're coming into the stream, do us a favor by liking and sharing this week's program. Of course, if you're over on YouTube, do us a favor by subscribing to our YouTube page. And here's a little secret. If you subscribe to the YouTube page, you would actually cause the algorithm to share this program with others who have not had an opportunity to see it. Now, for this week's editorial, we will be speaking about the unintended consequences of mass deportations. Now, in destination and transit countries around the world and across the political spectrum, debates about migration have been dominated by calls for increasing deportations of undocumented migrants. These policies are often justified by three main arguments. One, that they will deter future irregular migration. Two, they will enhance public safety. And three, they will improve the socioeconomic outcomes for the native-born population. Now, yet, despite these policies' significant fiscal costs, surprising little attention has been paid to evaluating them in terms of these particular objectives. One, what are the actual intended and unintended outcomes of forced returns, both in deporting countries and in migrants' countries of origin? Research shows that increasing removals and returns may deter some irregular migration in the short term. Nonetheless, without addressing the underlying drivers of migration, these policies may lead to a change only in individuals' migration strategies, rather than a noticeable reduction of irregular migration overall. Also, there is little evidence to support the notion that if enforced returns enhance public safety in destination countries. Studies have shown that deportations did not lead to lower crime rates in the United States, reflecting the fact that U.S. immigrants, including those without authorization, tend to have lower conviction and incarceration rates than native-born Americans. Now, narratives surrounding forced removals typically take the perspective of the deporting country, neglecting impacts on migrants, their families, and their communities of origin. Many deportees return with significant debt accrued from financing their migration. They have difficulty finding jobs and reestablishing footholds upon return, and often feel shame and experience stigma of having been removed. Now, moreover, the heightened vulnerability that comes with forced returns has fed into dynamics of violent crime in Mexico and Central America. These negative effects may come back to haunt deporting countries too. If forced returns lead to instability, social isolation, inability to find work, or other negative effects in communities of origin, this could generate new migration that would counteract the original deterrence intentions of these return policies. Policymakers, therefore, would be well advised to weigh evidence on the declared goals of these policies, namely whether they lead to deterrence, more security, and better jobs for natives, against their fiscal costs and real-world effects, both intended and unintended. Of course, in the current American zeitgeist, there is no conversation about undocumented migrants from Europe, Canada, Australia, or other parts of the so-called global north. These Gestapo-like raids seem to only target black and brown migrants. And of course, we recently heard that the Trump administration will in fact be opening a pathway for refugees of white South Africans to enter the United States, while canceling same for black and brown refugee applicants who have been waiting for years to enter the country. But alas, let us demonize the immigrant to prove that they, and not an unfair political system, are to blame for the challenges Americans face. And finally, folks, the Bob Report takes this time to extend its deepest condolences to the family of Samuel Latouche, originally from Felix Park in St. Andrew, who died suddenly in Dominica, where he resided. Mr. Latouche was a family friend and frequented the community of Pomrose, where he made many long-standing connections. We also extend condolences to Roseanne, Eric, and Erica Ambrose on the sudden passing of their dearly beloved niece and cousin. Nicole Alexander, at the time of her death, was attached to the 80th precinct of the New York Police Department as an officer. Her warmth, according to the 80th precinct, generosity, and positive spirit touched so many of us, and her absence leaves a significant void. According to the precinct, quote, "We will miss and always remember Nicole's contributions, the laughter she shared, and the impact she made on our lives," unquote. Now, may Nicole rest in peace, and may Samuel rest in peace, and may their memories be a blessing. Viewers and listeners, this is the Bob Report. We'll be right back for the first segment of the program. Please stand by. Hi, everyone. Thanks for checking out the Bob Report's social media pages. If you'd like to get more videos, show highlights, and watch our weekly live show, follow our Facebook, Twitter, and Instagram pages, and also subscribe to our YouTube channel. You can catch repeat episodes on Wednesdays at 4 and 5 p.m. respectively on CRFM Radio and GBN TV in Grenada. We are also viewed on Sundays at 8 p.m. on WPG10 throughout the Caribbean. Thanks for watching.
Tell as a commissioner of police, tell a politician, back off. You have no knowledge of the law. You have no knowledge of law enforcement. You cannot force my officers to do the wrong thing.
But that is somebody's son. That is somebody's child. That is part of a family. And I think that is the part that they are missing out.
Because E and F are apt to be used oppressively.
It's like because we don't see disabled people as sexual beings, which is ridiculous.
You mean they don't want to listen to your version of science? They have their own science. You have your science.
What we need to do is teach people to think and not what to think.
Today, it's too bad that everybody do what they want.
If I could forgive Bernard Ford, then I could forgive Bob Morris too. And today, on this day, I no more have anything in my heart for what he did.
The education system has to be very fluid and dynamic because we're living in very different and changing times.
Treating all your citizens equally, all your citizens fairly, recognizing each group, not discriminating against one or the other.
And viewers and listeners, welcome back to this week's edition of the Bob Report. Of course, before we get to our first panel segment, I do want to acknowledge some of the folks in the chat. Annika St. John, welcome. It's happy to have you. We're happy to have you here. Also, Mr. Arthur Langine, a happy Sunday to you. Akeem Lewis is here as well. Marvin Nelson, Ingrid Bourne, Onika as well is also here. Of course, if you're joining us on the Facebook Live, we'd be happy to get your comments in the comments section. And those of you who are here, just please remember to also share this week's live stream. And of course, those of you in the Maryland area, the Washington, D.C., Maryland area, as well as in Virginia, of course, next week, Sunday, the Grenada Embassy, of course, they will be holding the Grenada Independence Gala that will be taking place here in Maryland. I will be sharing more information on that later in the program. But of course, we hope to see as many of you there in the Grenadian community in the Washington, D.C. metropolitan area for that event. So at this time, we wish to get to the first segment of the program. Now, last week, the Eastern Caribbean Supreme Court of Appeal ruled in favor of the St Vincent and the Grenadines government in the so-called COVID-19 vaccine mandate case. Now, the St Vincent and the Grenadines Teachers Union, the Public Service Union, and the Police Welfare Association funded the lawsuit against the Minister of Health and Environment, the Public Service Commission, as well as the Commission of Police, the Attorney General, and the Police Service Commission as the respondents. Now, in a March 13th, 2023 ruling, then High Court Judge Justice Esco Henry ruled against the government on all 11 grounds and held that the vaccine mandate breached natural justice and that it contravened the Constitution, was unlawful, procedurally improper, and void. The government of St. Vincent and the Grenadines subsequently appealed the ruling, and the Court of Appeal heard the arguments on the 2nd of May 2024, but reserved its judgment. The Court of Appeal, by a 2-to-1 majority during a virtual sitting, upheld the government's appeal, saying that the government had succeeded in persuading them that then High Court Judge Justice Esco Henry was wrong in making most of the orders she made in her judgment. Now, in 2021, frontline public officers, including police officers, teachers, and healthcare workers, were required by the Public Health Department in St. Vincent and the Grenadines to follow special rules that required them to be vaccinated or deemed absent without leave and ultimately dismissed from their positions. However, some public sector employees refused to comply with the vaccine mandate and as a result were deemed to have abandoned their positions after being absent for 10 consecutive days in accordance with Regulation 31 of the Public Service Commission regulations and Section 73A of the Police Act. The mandate prohibited unvaccinated teachers from entering the workplace and deemed that they had abandoned their jobs. The dismissed workers took the government to court. They argued that Rule 8, subsection 1 and 2 of the Public Health, Public Body Special Measures Rules of 2021, SRNO number 28, was unlawful, unconstitutional, and void. Now, in an interview with NBC News Prime Minister Dr. Ralph Gonsalves of St. Vincent and the Grenadines said that was a nuanced decision that was taken by government during the time of the pandemic in order to save lives. The Prime Minister reiterated in that interview that any public servant who was dismissed during that period can return to the workforce and all job benefits will be reinstated. Prime Minister Gonsalves encourages persons to return to work, even as they have declared their willingness to appeal the case to the Privy Council, unquote. The report went on to say further, quote, the Prime Minister says, despite the ruling being in the government's favor, this is not a time to gloat, but rather a time for reconciliation, unquote. At this time, I wish to welcome our two first panelists, Mr. Jomo Thomas, who was one of the attorneys for the plaintiffs in this case, and constitutional attorney from Grenada, Mr. Ruggles Ferguson. And Jomo, I want to begin with you. First of all, gentlemen, welcome to this week's edition of the Bob Report. But Jomo, I want to begin with you on this question. Prime Minister Ralph Gonsalves is saying that the workers can, in fact, return to work. So why would there be a need to proceed with this case all the way to the Privy Council as we're hearing? Just unmute the mic, sir.
Thank you so much for inviting me yet again to your program.
Yes, sir.
You ask a very important question, and the Prime Minister's government, the ULP government, has been making this point ever since, I think it was August of 2022, inviting people to return to work. The question for the workers is not simply returning to work. The question for the workers is to return with all of their benefits, and the Prime Minister has said, yes, they will get all of their benefits. What is not said is that these workers have lost years of income, and by virtue of the fact that they have lost so much income, they have been put in a seriously hazardous position. Their mortgages have been forfeited, their insurance, all of those things that they had as normal functioning citizens who were employed were thrown into sharp relief. So many of the workers have returned to work. Some of them are insisting as a matter of principle that they want full reinstatement and not to have to reapply. But we as the attorneys have been telling workers as early as August of 2022, yes, you can return and in fact carry on your case, where then it was to the Court of Appeal, and now the unions have indicated that they want to appeal this Court of Appeal judgment all the way up to the Privy Council. So fundamentally, the question about returning to work is not the end of the story. More important question for the workers is that they want to be vindicated in law. They feel that they have not done anything wrong. And they are saying that the mere returning to work is not a just and proper remedy to the difficulties that they have. But many of them, I don't know how many, but many of them have returned to work based on the sheer pressure of having to be without salaries, without any form of employment over the last, since November of 2021.
So, in respect of the vaccine mandate, the COVID vaccine mandate, is that still in place? I don't think that is in place. So, the workers who return to work, did they have to retroactively then take the COVID vaccine, COVID shot?
No,
we're no longer in a pandemic.
Right. The request is is not for them to take the vaccine. The request is for them to reapply. And while the Prime Minister, while the government publicly says that they would return with all of their benefits intact, when they apply to the Public Service Commission, they are getting letters which says that they are resuming service from the day in which their application have been accepted. So there's some disconnect between the government's public relations rhetoric and what actually happens in practice when the workers go to the Public Service Commission.
So it's as if they will be starting from scratch as a new entrant into the service. Is that what you're saying?
Right. That's what some of the letters from the Public Service Commission seems to be indicating, and we have seen some of those letters.
Now, let me get into Ruggles. Let me bring Ruggles in here. And Mr. Ferguson, I first and foremost thank you for agreeing to appear on the Bub Report on such short notice. For full disclosure, we also did attempt to reach the attorneys that represented the government of St Vincent and the Grenadines in this case, but as I was sharing with both Ruggles and Jomo at the start of the program, sometimes government ministers and officials in any branch of government really, sometimes they dodge journalists like myself. So I'm not surprised that they did not take up the invitation. But Ruggles, initially in this case, the lower court judge here ruled in favor of the workers. They indicated that the COVID-19, the vaccine mandate was in fact unconstitutional, that particular judge. But then it went to the Court of Appeal, and the Court of Appeal essentially reversed that judgment. So can you speak to just the differences, and of course I will get Jomo in for this question as well, the differences in interpretation in respect of both judgments? What are your observations there?
Yes. Well, thank you, Kelon. Good morning, and good morning to all your viewers and listeners, and to my good colleague and comrade Jomo. So just again indicate, because I am actually learning for the first time on the program. There was an offer of the workers to return to work and for them to restore the full pension benefits and so. But this is an important case, and it's an important case because it's a constitutional case. It's a case that is grounded in the Constitution, and it involves several important principles. I'm not as familiar, of course, as Jomo is with all the ins and outs and arguments in relation to the case, but certainly the broad principles involved here. And the case arose out of the measures taken, emergency measures taken with respect to the COVID-19 pandemic, and ultimately resulting in these respondents deemed to having abandoned their jobs because essentially they failed to take the vaccine. And the case itself, just broadly speaking, touch and concern very important issues. One, critical when we speak about the Constitution is the separation of powers principle. The distinction between the role of the executive, the role of the legislature, executive being policy making, legislature being lawmaking, and the judiciary applying the law, interpreting the law, and enforcing the law ultimately. It also deals with the delegation of authority. So the role of the judiciary here is a role that is being played out now because the applicants having been aggrieved, the respondents in the appeal being aggrieved as a result of losing their jobs and losing possible benefits, have come to the court for relief under the Constitution. One, the case itself deals with delegation of authority. Two, Parliament being the lawmaking entity of the state responsible for making laws for the peace, order, and good government of the country, delegating certain authorities to a minister of government during the Minister of Health, that is, during the COVID-19 pandemic. It deals with fundamental rights and freedoms, it deals with pension rights, and it deals with the role of Independent Service Commission. So very important issues. And what the Court of Appeal, by majority, reversed the High Court judge because the High Court judge basically ruled that there was a breach of the separation of powers principle here in terms of the role of Parliament and the role of the executive, being the minister introducing these particular measures. And of course, the Public Service Commission, which is supposed to be an independent commission under the Constitution, the respondents, being the applicants in the court below, contended that the Public Service Commission ought not to be directed by any other entity or authority. And they contended that by the minister giving an ultimatum to say that, in a sense, people who are not vaccinated could not attend the workplace, certain categories of workers. And if you are out for 10 consecutive days, then you're deemed to have abandoned your job. Then the minister was encroaching on the authority of the Public Service Commission there. So it covered these several areas, but in a mouthful, what the High Court judge did is to agree with most of the arguments, it seems, advanced by the applicants in the court below, saying essentially, lawmaking is for Parliament, and I'm just putting it as simply as possible. Lawmaking is for Parliament, not the minister. Under the Constitution, the Public Service Commission is the body with the role that hires, fires, and disciplines public workers, public sector employees. And as a result of that, the fact that the minister introduced certain measures which in effect led to the dismissal of employees encroached on the authority of the Independent Public Service Commission. And then thirdly, that the right to a pension, which the applicants, respondents advanced in the court, that listen, we have worked for X number of years, and if you come and dismiss us now, just because we haven't taken the vaccine, it would mean that we lose all our pension rights. And therefore, the loss of our pension rights in that manner affects our right to property as guaranteed by Section 6 of the Constitution of St Vincent and the Grenadines, and is therefore unconstitutional from that angle. So there are these broad arguments which the judge agreed with, and in the Court of Appeal, interestingly, it was a majority judgment. It was a 2-1 judgment, and on the face of it, reasoned judgments by all parties. On the face of it, a very good and well presented dissenting judgment by Justice Walbank. So what you have, in a sense, is not a unanimous interpretation of the issues, the very important constitutional issues, with one judge going a particular way, 2 judges of the Court of Appeal going a particular way, and 1 judge of the Court of Appeal going in a particular way. And in fact, Justice Esco Henry, who is a very good judge, who has a very good reputation on the bench, is now a member of the Court of Appeal. Of course, she could not sit on her own matter in the Court of Appeal, but she's there now. And if I could just say, maybe one of the issues of bringing a matter to a higher court is really to settle the law. It might go to the Privy Council and they might rule 3-2, because 5 members sit at the level of the Privy Council. But it will settle some of the important legal principles here. And if there is a pandemic again, then all parties will be guided as to how to approach the situation.
Let me bring back Jomo here, because Jomo, one of the things you pointed out following the ruling was the dissenting justice's opinion. So I want you to articulate for us, for the benefit of our viewers and listeners, that particular dissenting opinion and what stood out about the dissenting opinion. And in respect of that opinion, do you believe that taking this matter to the Supreme, well, not the Supreme Court, again, to the Privy Council, somehow would have that dissenting opinion as the basis for which you will then go on to, and the other attorneys for the aggrieved will then go on to take this case to the Privy Council?
Right. I want to unite completely with what Ruggles said, because indeed, this case throws up a number of critically important issues: delegation of powers, the role of Parliament, the role of the Public Service Commission, what kind of rights are guaranteed and how these rights are to be seen and respected by government officials. And he also made the point that this was a majority decision, 2 judges agreeing and 1 judge disagreeing. The judge disagreeing with Justice Walbank. In fact, Justice Walbank's dissenting opinion is a very long and detailed opinion. I didn't check precisely, but it's probably equal in length or longer than the government. Having read the decision, I think there's room for disagreement on both sides, as is evident with a dissenting opinion. You don't have all of the judges agreeing, but Justice Ventos is a very, very, very good judge. In fact, he wrote the book on Caribbean Constitutional and Administrative Law. So, in fact, I heard the Prime Minister making that precise point, that he's not really concerned because Justice Ventos is a constitutional lawyer and Justice Walbank is a commercial law specialist. Having said that, though, I think that there are a number of points which Justice Walbank makes which are of critical importance. I think he spends a lot of time he spent a lot of time talking about the role of the Public Service Commission, and he also talked about the ways in which the government's mandate 8.1 and 8.2 intruded onto the independent decision-making process of the Public Service Commission. He agreed with the respondents, the claimants in the case below, that in fundamental ways, you cannot say that these workers abandon their jobs for the precise reason that historically in the common law and in the body of law that have developed over the years, abandonment actually meant voluntary removal from your place of employ. So he was very, very strong on that point. And in fact, in our papers, we clearly pointed to the black letter law as to what abandonment meant. The majority opinion said that on its face, once sections 8.1 and 8.2 were brought into focus, particularly understanding that section 5 said that you have to be vaccinated. The mere fact that a list of persons are presented to the Public Service Commission and they are not on the list of vaccinated persons, then it automatically meant that they were not in compliance with the law, and consequently would be deemed to have properly abandoned the job. So there's that disagreement there. And then Justice Walbach spent an inordinate amount of time talking about the issue of proportionality, which was one of the arguments that the claimants in the case below, which Justice Henry agreed with, and the respondents in this case, which the majority disagreed with. They argued that the act of removing them from causing them to be fired, to be dismissed from their job, was fundamentally disproportionate. And Justice Walbank again agreed with that. And he really, really, I think, meticulously went into that to show how that could not be the case. In fact, in his dissenting opinion, he talked about the fact that there were built-in, less intrusive, restrictive ways in which the government could have dealt with the COVID problem without dismissing the workers, thus denying them their constitutionally protected right to property. And he said that in the act in SRO 28 itself, where you could have been removed from the workplace, one, without being dismissed, and two, there was a built-in disciplinary procedure which could have been employed. So the government elected not to simply remove the workers, could have put them on unpaid leave. In fact, in the case below, we proposed about 13 different things that could have happened without the workers losing all of their rights and benefits as the government elected to do. Justice Walbank seemed to have agreed to that and pointed to some of those in his decision. So I think that when the matter comes up, in fact, there are points where he disagreed. He disagreed with Justice Henry that some of the actions of the government were unconstitutional. But even when he disagreed that they were unconstitutional, Section 8.1 and 8.2, he still found that they were void. And on the issue of proportionality, he really dissected that, pointing to the law, pointing to the traditions on issues of proportionality. He pointed to a very important case by Justice Sumpton, the celebrated Lord Sumpton jurist, who it was a case of an Iranian bank. I think it's Melhat was the name of the case. He did a lot with that, and the point that he sought to show was that when the government did this, he disagreed with the court that its analysis of the proportionality question was not sufficiently rigorous, and consequently simply fell in line and agreed with the government that these workers did not have any constitutionally protected right to property. But I think it's a decision that's going to be debated for some time yet.
Yeah, certainly, and absolutely. Now, Ruggles, we have a similar. I don't think in the case of Grenada at the St. George University that the workers, in fact, took the kind of legal action that we saw, the class action, legal action that we saw in the case of St. Vincent and the Grenadines with respect to the teachers, the police officers, and the other public servants. But what broad implication? Let's say if a worker decides, in Grenada, who was aggrieved at St. George University for refusing to take the vaccine as well, that they want to challenge what was done to them. Will this case set a precedent that would perhaps be a barrier from them challenging that matter, especially in the context of not only Grenada, but in the OECS?
Right. It's important to note, Kellon, that this case actually deals with what you call public law rights. In other words, they address measures that the government has put in place and say, listen, there's an emergency, we have to save lives, and this is what we are going to do. Through rules 8, 5, etc. We do 1, 2, 3, 4, 5. If you work in these workplaces, you need to take a vaccine. Now, that's a public, so it's a public law case, and that's why it was brought in St. Vincent addressing breaches of constitutional rights. Because you can only take a constitutional matter against, in this case, the state, in relation to SGU, because there were similar issues in Grenada with SGU, where SGU now, basically as a private employer, says, listen, if you are to continue working here in the context of the COVID-19 pandemic, these are the new rules, 1, 2, 3, 4, 5. This was not something imposed by the government, by the state. It was imposed by SGU. So, for example, if there is to be a cause of action on action taken in court, that action will be taken by the employer against the SGU or whatever private entity was involved. Now, of course, these other constitutional cases will have impact because the court has made certain pronouncements in the course of it, so it will be applicable. But it's different because in the case of St. Vincent, they introduced particular specific measures. So that's the main distinction. But I want to also make the broader point, Jomo in a sense touched on it. When you have these constitutional cases, the beauty of these constitutional cases, and almost every single constitutional case, even if it is brought by one individual or 10 individuals, the judgment in those cases do not impact just that one or those 10 individuals. It impacts broader society, because what the court is doing is interpreting the Constitution. So in future, when anybody brings a similar matter, in this case, the constitutional right involved here was the deprivation of property. The respondents argued in the court below that, listen, you have dismissed me. And as a result of terminating me by saying that I have abandoned my job, I have lost my pension rights. And therefore, losing my pension rights deprives me of property, because pension money constitutes property under the Constitution. So you have deprived me of property. It's interesting how Justice Wallbank, who indeed is a commercial lawyer, I think he's trained. His particular area of training is in commercial law, but that does not mean he's an experienced judge, that he does not appreciate the Constitution and constitutional concepts. because he was very detailed, very meticulous in his approach to it. And he was saying, listen, if you and probably I should try to dissect what I understand to be the two arguments here. In relation to the state says simply this: we are in a pandemic. One, we have to save lives. We have to balance the interests of the community, of the individual, with the interests of the wider community. And this is a new rule. If you miss your work 10 consecutive days, you don't come to work, then you will be deemed to have abandoned your work. And you basically lose your job and you lose your benefits with it. It is necessary that we do so because we have a wider public interest to protect. And in the Constitution, you have fundamental rights and freedoms, but those fundamental rights and freedoms, it's balanced against the individual right. The individual right is not absolute because it is measured against the wider community right. The arguments of the respondents, as I understand it, goes something like this. We have not abandoned our jobs. We are willing and available to continue to work. For whatever reason, whether it's religious, medical, or other reasons, matters of conscience, we do not want to take the vaccine. And therefore, we have worked for X number of years. We are available. So if you tell us that failure to take the vaccine means you can't come on the workplace, we are presenting ourselves for work. And just automatically now, after 10 days, we can lose everything that we worked for over the period. That must be unconstitutional, especially as you have not given us an opportunity to be heard as to why we are not taking the vaccine. And the Court of Appeal majority judgment, I noted, focused on that. They are saying, listen, no pension right has been breached. And there may be fertile ground for appeal in relation to that, because the court is saying, as I understand it, no pension right, because if a pension right, if you have a pension right, must be one that has accrued and you're entitled to at the point in time. But if you abandon your job, you're not entitled to it, and therefore you can't claim a pension right, as opposed to Justice Walbank, who say, all right, if you say you can't come to work because there's this wider community interest to protect, then in relation to your pension rights, the effect of it really is that you are depriving them of the possibility of their pension rights. But what he's saying is that Section 6 of the Constitution says, listen, it's not an absolute right, and therefore you could have said, listen, you're entitled to compensation for the right. He says if there is a breach of Section 6, then the Constitution says you must be compensated. So he has taken a much broader approach to it than the Court of Appeals majority very strict approach. You didn't come to work, you lose your benefits, and you lose your pension right. So you can't say your pension right has accrued. So, but I mean, whatever at the end of the day, as I say, I was not involved in the case, so I can't comment and would not attempt to comment in any definitive and conclusive way. But what I can say is that cases like this have broad implications, not just on St Vincent and the Grenadines, but the wider Commonwealth, because we have similar constitutions. And therefore, if there is a case in Grenada, if there is another pandemic, and a case in Grenada arises, then that case in St. Vincent will be an important precedent. And that is why, again, sometimes it is better to let the highest court ventilate on the issues and make a final determination. Because as it says, the final court is right because it is the final court. So whether it's a 3-2 decision or not, the majority there will become the law for the rest of the Commonwealth.
Gentlemen, this is such an important conversation. And of course, we have someone's Cheflon Baliante. That's such a distinctive
Valentine.
That's such a distinctive Vincentian last name. It was a travesty of justice. It was a judgment that reinforces tyranny in St. Vincent and the Grenadines. Very strong words there from that person.
But you see, Kelon.
Yes, Jomo, yes.
I think Ruggles encapsulates the arguments, but I think that Justice Walbank in his dissent makes these points. He says the majority moves from the premise that sections 8.1 and 8.2 are constitutional, and therefore drew the analysis from that. But he argued that in his respectful opinion, 8.1 and 8.2 are void, and consequently says, for example, he says, when you look at the proportionality test that is established in these kind of cases, where, and basically the proportionality test says you have to look at whether the objective is sufficiently important to justify the limitation of a fundamental right, which is the right to property, whether it is rationally connected to the objective, whether a less intrusive measure could have been used, and whether, having regard to these matters, to the severity of the consequence, a fair balance has been struck between the rights of the individuals and the interests of the community. Justice Walbank conclude that yes, it might have met 1 and 2, but certainly there was he disagreed. He agreed that there was a less intrusive measure that could have been used, and he pointed to the very 8.1 and 8.2 itself, which says we can discipline you or we can ask you not to come to the workforce. And he says once that is happening, then the question becomes really, really ticklish. And he, as I was saying, he cited a judgment from Lord Sumpton in which he says, in determining proportionality, that depends on an exacting analysis of the factual case advanced by the defendant. So when he talked, for example, when looking at the issues of property, he said the claimants asserted, the respondent in the appeal asserted that there were pension rights. The appellants simply said there was none, but he said there was no evidence on the record apart from their mere saying that there was none, and consequently, in the absence of any evidence, which in fact or in law, which decided whether there was they had accrued pension rights, he said you have to move from the premise that that's the evidence in the case that there is some pension right, and then he goes in to talk about the litigants and the years of service they had and so on and so forth, and came away with the understanding that there was a less intrusive measure that could have been used, 1, and 2, that a fair balance was not struck between the rights of the individuals and the interests of the community.
Very interesting. Gentlemen, this is a case that we will be continuing to follow because, of course, there are other vaccine mandate injury cases. I've not paid attention to what's happening in the context of the Commonwealth that under which St. Vincent and the Grenadines jurisprudence falls. But there is a recent case in Michigan as of last week where also, I'm not sure if you saw that, Jomo, maybe you did, or maybe
yes,
you didn't, I did. Where one of the pharmaceutical companies, they are now duty bound to compensate the workers who refused to be vaccinated, and to the tune of a couple $1 million, I believe. But I believe the judge capped it at a particular sum. So there appears to be a lot of litigation around notions either of vaccine injury or the question of refusing to take the COVID jab on constitutional grounds, where religious freedom grounds and things like that. So this is not something that might be going away soon, and that's what we'll be watching the space. So Ruggles and Jomo, I'll get to you, gentlemen, for some closing comments. Starting with you, Ruggles.
Yes, well, yeah, thank you. And again, let me commend you for always taking up these public interest issues. Of course, this is a matter of not just interest to St. Vincent and the Grenadines, but as I said earlier, to the wider Caribbean.
Yeah.
And there are always lessons for both sides to learn. And not just the both sides involved in the case, but for future governments. In the event that there is a pandemic again, how do we approach it to ensure that we keep within the confines of the Constitution to avoid a multiplicity of possible litigation that can arise? So from that standpoint, it would be good to get a higher court to say, well, listen, because whatever the Privy Council says, the Privy Council being the final court of appeal for St. Vincent and the Grenadines, will be the law in relation to this matter. But at the same time, those involved in it ought to be commended because we have a constitution, and too few occasions these constitutions are triggered, and the constitutional principles. We are having more and more of it in the OECS now because the Constitution is the supreme law. It affords certain fundamental rights and freedoms, and it is important. And in St. Vincent and the Grenadines, we had the trade unions, which again show the importance of trade unions in a community, because without the trade union community, this matter possibly would have gotten nowhere. As I was making the point in another forum yesterday, the importance of these institutions, like trade unions, in our democratic structure. So I think
please say that louder for some in the back of the room in Grenada who have been attacking.
Well, I can say that. Well, let me repeat. Trade unions and other institutions are critical to a functioning democracy because there are just some things that would get nowhere unless there is the support. And in this case, there was the support of the unions in St. Vincent taking up these particular issues. So it's all a learning experience, and I'm sure, as you said, there will be future programs on it, and you can't do justice to a matter like that in 15 or 20 minutes. It requires
absolutely not.
Really,
absolutely not. And I want to respect Mr. Duncan and Mr. Chastanet. Yes, sir. And thank you again for always agreeing to come to being the legal cavalry, I call you, when we have these matters. Over to you, Brother Jomo, sir, for some.
Yes, it's always a pleasure to come on. It's always a pleasure to be on the same program with Ruggles Ferguson, treasures trove of information and knowledge.
Yes.
But yeah, this case is a very critically important case. I was proud to be part of it. It's not over yet, based on the remit that we got from the unions. So more than likely, it's going to be decided at the Privy Council. I want to take a slight shade with what my brother and friend Ruggles Ferguson said, that we have to find out, these cases determine how government should approach a pandemic. Well, there are 14 countries in CARICOM, and 13 of them took a particular approach. None of them took what Justice Walbank called a draconian approach, except for the government of St. Vincent and the Grenadines. So there's some clear guardrails as to how to approach it, and some governments went in a particular way. It's instructive that when St. Vincent went rogue and put their mandates in, it was the very week before the government of Antigua had removed its mandate. But I want to end by saying this. The Prime Minister said, now is not a time to gloat. Now is a time for healing and reconciliation. If we conclude that there need to be healing, we have to think through who did the injury, who caused the injury, and why is there a need for healing and reconciliation. But you don't get any kind of contrition at all on the part of the government because Prime Minister Gonzalez insists that he and his government has done nothing wrong. Well, if you did not do anything wrong, I'm not so sure why you want to heal. So, but yeah, this case is going to be important. As I said, I'm glad to be part of it. I'm glad the trade unions took this up and were willing to run with it and to ensure that it got to this point. And we're going to be talking for a long time. So thank you for inviting me, and hopefully we can have people who are even more preeminent in constitutional and administrative law than myself can come on and do further erudition on this matter.
Absolutely, because it does need, and of course we know that Legal Eyes is a program that I've now started to watch for my own purposes, educating myself on the law with Mr. Lane, Ewart Lane, on Sundays at I believe it's 8 p.m. on YouTube. He does a good job, and the panelists, Ruggles, you've appeared there, Jomo. I've listened to a lot of your conversations there. But Jomo, just one thing.
It's 7 p.m. by the way.
7 p.m., not 8, 7 p.m. Perhaps Dr. Gonzalez is saying it's time for healing. Do you think maybe it's because it's an election year there in St Vincent and the Grenadines, and that might be sort of a dog whistle for votes, sir?
Well, all of us, any keen observer across this region knows that PM Gonzalez is an astute politician. He knows he's looking for an unprecedented sixth term, and he wants to put himself in good stead. And even some of his top supporters and talking heads would tell you that this, the vaccine mandate case and the pain and suffering it caused, because that pain was not caused just to 271 persons, to their family, their friends, then the whole fact that you had the vaccine, people took it either out of fear, out of loyalty to the government, and then the mandate itself. So there was and a lot of people have suffered from adverse events and so on. So he's trying to triangulate all of that to put himself in a position where he can again triumph whenever the next elections are called. They're due constitutionally by February of 2026, but he has indicated that more than likely they will be called before the end of the year.
Before the end of the year, absolutely. And we would, of course, be watching the space to see what unfolds there. Gentlemen, thank you so much for appearing on the Bob Report this week. And viewers and listeners, we thank you for staying with us. Of course, we are going to quickly get to the next segment after we take this break. But if you're just coming into the space, we were just having a conversation on the vaccine mandate ruling out there in St. Vincent and the Grenadines. Of course, the Eastern Caribbean Supreme Court, they ruled against the plaintiffs in this matter and ruling in favor of the government of St. Vincent and the Grenadines. We are going to take a quick break and come back to find out what is all about this new citizenship by invitation that was recently announced by the government of Grenada. And when I say recent, earlier this year, earlier this month, as well as earlier in January, there were some conversations around citizenship by invitation. We are going to get into that conversation, the implications, the economic implications, of course. There are also new measures that have been put in place around an OECS level looking at CBI programs throughout the OECS, and we have a conversation about that as well. So we will take a quick break and come back for the second segment of the Bob Report. Thanks for staying with us. Please stand by.
Tell us, a commissioner of police, tell a politician, back off. You have no knowledge of the law. You have no knowledge of law enforcement. You cannot force my officers to do the wrong thing.
But that is somebody's son. That is somebody's child. That is part of a family. And I think that is the part that they are missing out.
Because E and F are apt to be used oppressively.
It's like because we don't see disabled people as sexual beings, which is ridiculous.
You mean they don't want to listen to your version of science? They have their own science. You have your science.
What we need to do is teach people to think and not what to think.
Today, It's too bad that everybody do what they want.
If I could forgive Bernard Ford, then I could forgive Morris too. And today, on this day, I no more have anything in my heart for what he did.
The education system has to be very fluid and dynamic because we're living in very different and changing times.
Treating all your citizens equally, all your citizens fairly, recognizing each group, not discriminating against one or the other.
We seek the truth.
Would you be handing your resignation to the Minister of Culture tomorrow, sir?
No, I will not.
The leader of the opposition, you have accused your government, sir, of using the Grenada Development Bank to facilitate the financing of personal loans for certain government ministers.
The other side is in no position to talk about those issues, and I will leave it there.
We discover new perspectives.
You know his leadership style, and so many are saying, why are you coming now to talk about those issues?
Now is the time to speak. You have the right to decide who will take over.
And you met with Dr. Mitchell, and perhaps you might want to confirm what that meeting was about in your response. But
Dr. Mitchell, like myself, are Grenadians.
We ask the right questions.
Why was there no report on the work done of the commission? And how is this new committee different from the commission that was initially established back in 2022? So who are these elements that are using you?
I'm disappointed in my political leader.
And why is that animating those political conversations now?
This is a very interesting question.
The Bub Reports with Dr. Kellon Bub. Thought-provoking, truthful, unbiased, and truly original reporting.
Should your loved ones pass on, they deserve to be treated with dignity. And at S.A. Johnson Funeral Home, we can provide you with that service. We can take you every step of the way during your sorrowful moments. When that need arises, call S.A. Johnson Funeral Home at 347-777-9797. That's 347-777-9797. S.A. Johnson Funeral Home is a Caribbean family-owned funeral home here in Brooklyn, providing funeral services, but in a dignified way. From cremation to burial to the repatriation of your loved ones, you don't have to go through the hassle, as we provide exceptional service that allows you to mourn and heal peacefully. For more information, visit our website, www.sajohnsonfuneral.org. Send us an email at sajfuneral@aol.com or call 347-777-9797. S.A. Johnson Funeral Home, because you deserve to be treated with dignity.
And viewers and listeners, welcome back to this week's edition of the Bub Report. Now, Grenada recently announced the launch of a Citizenship by Invitation program. Announced initially on the 27th of January this year, this initiative is diverges from the conventional CBI model that is currently in place, that directly invites, and this Citizenship by Invitation will directly invite select high net worth individuals to apply for citizenship rather than opening applications to the public. This invitation-only program was developed in collaboration with industry leaders, and according to the government of Grenada and the Investment Migration Agency in Grenada, it aims to attract top-tier investors in sectors such as renewable energy, technology, banking, and hospitality. Now, Grenada's strategy, according to the CBI, the Investment Migration Agency, underscores the country's commitment to fostering targeted economic growth by bringing in expertise and capital that aligns with its national priorities. Now, at a preview event held in September last year at New York's Amman Hotel, Prime Minister the Honorable Deacon Mitchell of Grenada outlined the country's vision for investment-driven development. A key focus of this initiative, he says, is supporting Grenada's post-Hurricane Beryl recovery, with renewable energy at the forefront of the nation's long-term economic strategy. Now, here to make sense of this issue and CBI issues in general, Mr. Richard Duncan, OBE, who is the chairman of Grenada's Citizenship by Investment Committee, as well as the Honorable Alan Chastanet, who is a political leader of the United Workers' Party in St. Lucia, as well as the leader of the opposition. He was also the former prime minister of our neighbor to the north in St. Lucia. Gentlemen, welcome to this week's edition of the Bub Report. It's good having you. Thank you for laying in wait while we barrel through that very important vaccine case over there in St. Vincent. But both of you have been on the program before. I don't think you've been on the program at the same time, but Mr. Chassenay, CIP issues is something that you indicated that you're passionate about. So we decided to bring you back to have a conversation about that. And what better person to do that with than Mr. Richard Duncan of Grenada. So gentlemen, welcome to this week's edition of the program. And Richard, if you can just unmute.
Okay, so
yes, yes, we can hear you now, sir. Go ahead. Yes.
Yes. So good morning, Kellogg. Good morning to the viewing and listening public, and good morning to Honorable Alan Sastene. And it's a pleasure to be on this panel once again to elucidate on the issues concerning investment migration, CBI, and the like.
Yes, Mr. Chassenay, welcome, sir.
Great to be here, and thank you very much for the warm-up of your discussion before. It was really very fascinating. Obviously, being a prime minister during the same period of time, it invoked and reminded me of so many of the tough decisions we had to make.
Absolutely, and of course, some may say that perhaps that was the election hill that probably your party died on going into the election. But that is for another conversation, sir. Now, Mr. Duncan, I want to begin with you, and then I will get to Mr. Chassenay on this question. Let us talk about CBI revenue targets versus those long-term revenue projections for Grenada. Now, there were conversations around, again, those windfall revenues that CBI generated over the last 2 years in Grenada. So can you speak to where we are currently? And are we expected to see a downturn in the conventional CBI applicants?
So yes, Kellon, you used the right word. It was a windfall. I think the record is very clear as to the fact that 2023-24 marked the walking through by the Grenada program of a backlog of Russian applicants, and being the only jurisdiction processing Russian applications at the time based on the backlog that we had when the cutoff was agreed to with the US. That resulted in the windfall to which you have alluded. So the issue right now is, how do we get back to the Russian-Ukraine war levels of applications? And that is in the region of 550, 580 applications. So in terms of new applications for 2024, we have not been able to hit the $500 mark. In fact, the statistics release shows that we were able to hit 420 new applications in 2024. And the target, obviously, for 2025 is to get back to the 550, 580 mark where we were prior to the Russian-Ukraine situation.
Now, Mr. Chassenay, I want to bring you in here on this question because, of course, many countries in the OECS, have CBI programs in place. Talk about the St. Lucia experience in respect of CBI and in respect of revenue targets and the role that CBI plays in Grenada. Of course, we have something called the National Transformation Fund, where a lot of that CBI revenue is used for capital projects in the country. Is it the same in St. Lucia, or is the approach different there?
I think that the approach was very similar. When we came into government in 2016, St. Lucia had only just recently launched the CIP program. So there were a lot of regulations that still were not there. The program itself, in terms of its offerings, were narrow. And there was a tremendous amount of competition within the region. And that competition not necessarily very transparent all the time. So the question really became, what was the price of the CIP program? So we became accustomed to seeing a legislated a price, but being told in the market that was not being adhered to. So in the case of St. Lucia, what was very shocking to me when we first came in was the due diligence part of it. There's supposed to be really three mechanisms that most of the countries use. The first one is an online program that exists called WorldSpan that can give you a first indication of somebody, but it's not very thorough because it's very generic in a sense. The second one is that we have what we call third-party companies, accounting firms generally, that do individual audits on the individuals. And those audits include their offices from where they come from to confirm all the information they've provided on their bio is correct, where they're working, where do they live, what assets do they own, all of those things are vetted. And then the third one is through our own regional security force. The regional security force one is very important. And I don't think a lot of persons would have really connected the dot on that third one. We are part of the OECS Basse-Terre Treaty and of CARICOM. And in those treaties, we give each other certain rights, citizens from both the OECS and CARICOM. Clearly, the treaty, the benefits as an OECS citizen is much more robust. In the case of St. Lucia, a Dominican can come to St. Lucia and literally live in St. Lucia as if they were St. Lucian. In the case of CARICOM, it's without traveling without visa, a limited period of time, I think it's 90 days, that you're allowed to spend without having to put a visa. We also make it much easier for persons to get work permits to work within the CARICOM region. And it is for that reason, the regional security checks are so important, because that is what the checks and balances that are put in place, or the guardrails that are put in place, to make sure that there is some level of standard and protection that's given to our countries, and that the persons that we're allowing to become in as citizens of our countries, who are automatically now going to benefit from the Basse-Terre Treaty of OECS and the Chaguaramas Treaty of CARICOM, that they've been checked, and that the Trinidadians and Jamaicans and Guyanese and all the other countries can be assured that there is a common standard. And I was shocked to find out when I came in that that was not being done. And if you just want to think of the 4 OECS countries and the number of files that were being processed, and you had a fight going on between INPACS and RSSS, as to who was ultimately responsible. Applications were being sent to them individually. And it took us almost 2 years with the assistance of the British and the Americans and the Europeans, obviously along with our own governments, to finally get that resolved. So I think that that was a major flaw that existed at the time, along with a common price practice in the marketplace.
And I want to bring in Mr. Duncan here, because again, that is a question that I'm glad you expanded it a bit here to contextualize the role of the OECS and sort of this, to me, as if the way that I observed this before was as if there was a competition. So let's say Grenada offered a program at a certain price, then St. Kitts may decide to offer that same program at a lower price, or particular incentive structures that might exist in Grenada. St. Kitts may say, well, we will sweeten the pot more and offer more incentives. Mr. Duncan, on that question, in respect, I do know that at the OECS level, there has been conversation around looking at how there can be joint regulation of the programs. What is that going to look like? And what are the implications of doing that?
Okay, so Kalon, before I jump to that specific question, just to go back on, one of the points that Honorable Shastini made, and that is the question of the quality of the due diligence that is done by third party. And I think all of us have been driving to make sure that those third parties are, first of all, reputable, credible, and that we make sure that they do what they say they're supposed to do. So there are different ways of doing that, i.e. sometimes we send the same application to do different DD forms to see what it is they come back with. So there are little techniques that you use, along the way. But most importantly is the role of the JRCC. I think that's the term that Honorable Shastin is looking for, the Joint Regional Communication Mechanism, right? Where all applications should go through, must go through. They have to go through the JRCC. Not everyone was compliant. The evidence suggests that people choose to send some, not send others, and so on. That, I believe, has been put to bed by virtue of one of the principles, one of the 6 principles, we call them the US CBI principles, that were agreed to in St. Kitts in January of 2023, where all applications must go through. And on top of that, denials have to be reported to the JRCC. So there's no arbitrage that you get denied in country A, so you show up in country B, and unknown to them, you get through. So that has been put to bed, and I think Mr. Shashin is saying that when he came in, he discovered this and he attempted to fix it, and that was maybe 2014, 16, 17. But in my tenure, which started in 2022, July, we have worked assiduously, and as I say, in 23, the joint principles have been instituted. Coming now to the regional regulator, I think that was your key question.
Yes.
Right. So obviously that is critical. A precursor to the regional regulator is what we call a memorandum of agreement among the 5 jurisdictions. And one of the points in that memorandum of agreement is the minimum price, where it is agreed that the minimum price is set at X, right? So we now know that the race to the bottom, which had gained acceleration in recent times, has been brought to an end. So the race to the bottom is over. So if the minimum price is 270, that is it. Meaning that the monies received clean and clear into the treasury is 270, for example. If the minimum price in another jurisdiction is 350, right? Their minimum price is 350, then that's it. So everyone minimum price is at X and above, right? X and above, so that you can have different minimum prices based on how people calibrate their program, but it cannot fall below the agreed minimum price.
And what is that minimum price?
I believe
the current minimum price.
The current minimum price, I believe, is $200,000 across the board. Right?
Okay, that's $200,000 US dollars.
Right.
Okay, now go ahead.
Okay, so the regional regulator is critical. It is always true that in these capitalist enterprises that the innovators, the entrepreneurs run ahead of the regulators. And oftentimes when the regulators show up, sometimes it is too late. The question is it too late that the regulator is now trying to show up? Now, an independent regulator backed by a uniform law and a common institution over the 5 jurisdictions, to me, is key to the future of the CBI. If we do not regulate, then we will eliminate, meaning that our development partners will not sit idly by and see the risk that these programs potentially pose to their jurisdiction not being lowered and managed. So a legal consultant has been retained, consultation is going to be taking place, legal drafting is going to be done, and obviously the deadline is that by the end of 2025, we should be able to go to our respective parliaments and bring into force that uniform regulation. The last point I want to make on it is that if we do not start off by designing the teeth that regulator would have, we may as well abort the project since now. Unless the regulator has teeth, let us abort and do not waste time and money. So the regulator must have the power, must have the capacity, must have the reach to regulate the industry. Not just the CBI units or the CIP units, the industry, which include your market actors, it includes your DD firms, okay, and of course your local agents. So I just want to make those several points on the question of
thank you so much, Mr. Duncan, for this. Mr. Chasney, that is a conversation we had in background, and that's one of the things that you expressed concern about in respect of sort of this Wild West activity that has been happening across the various jurisdictions. So I'm sure what Mr. Duncan just articulated here is music to your ears, sir.
It is and it's not.
Okay.
The breaches have been so egregious, so audacious, and so corruptive. I think that the idea of just starting afresh and forgetting about what's happened in the past is the wrong premise. You know, what has been at risk, which is our own national security and the integrity of our own banking system. When you talked about the previous conversation you were having, and they were speaking about a balance, the corresponding action. Look what has been at risk. And we have sat silently by and watched the most outrageous behavior. And you're 100% right. I'm not sure, with the absence of a very strong regulator, an independent regulator, that we're going to fix the problem. And this is why the United Workers' Party, which I head, has already made a policy pronouncement that should we win the election, that we're going to demand that this CIP program actually be one program managed at the OECS level, meaning that we're going to take away, we ought to take away these individual programs that are competing against each other. Because the benefits are all the same. There is absolutely no difference between, well, Grenada is a bit of an exception because of a benefit you have with the US. But other than that, all the OECS countries have the same thing. About the same number of visa-free accesses, the size of our economy, the trade agreements we have, all are very, very similar. So we would really want to see that there be one singular program. I don't have a lot of confidence that the regulator is going to work. I'm concerned that there's no sense of urgency. Here it is. We've seen what's gone on in St. Kitts. We've seen what's going on in Dominica. We obviously see what's going on in St. Lucia. I've heard rumors about Grenada. I don't have a lot of details about what's taking place in Grenada, but certainly St. Kitts, Dominica, and St. Lucia, I'm very much very familiar with what's been taking place. To say that we're going to have a regulator in place by the end of the year is absurd. And I think that many people would have believed what I believed. When I heard the governor of the central bank come out and talk about a regulator, and a board has been put in place, I thought that that was the regulatory board. To only find out, no, that's a board that was put up to help establish a regulator. So this further procrastination that seems to be taking place. I think that the proof of what I'm saying is there. The moment now that all of these countries have temporarily had to now put in some level of regulations, and there's obviously many more eyes watching what's going on, the number of applications went down. In the case of St. Lucia, from 2016 to 2021, we had 850 applicants. This government, in a matter of a year and a half, has had over 11,000. 11,000, which potentially could be as many as 44,000 passports. How do you do that? I mean, I'm sorry to say in the case of Grenada, but Mr. Morgan's 100% right. It was because everybody else in the world was not taking Russian applications because of what was taking place in the Ukraine and because of the sanctions that were taking place against Russians that everybody else stopped, but Grenada didn't. So it was that little caveat that allowed them to get the number of applications that it did. But now I want to ask the question, who are all these Russians? And they now have access to all of the OECS and all of CARICOM. Was that done in the best interest of all of us? Should an individual country that's benefiting from a regional agreement, of which you're talking about freedom of movement of individuals within the region, which is a security issue, of transparency in terms of money transactions, should everybody be exposed? And are we being exposed?
Okay, so with that pause, let me come in with that pause there and say to Mr. Shastini, that the Grenada program, as you see, as far as you are aware, appears to be not mired by the kind of controversies and issues that you hinted to in St. Lucia, Dominica, St. Kitts, Antigua. We have, over the years, from its inception, attempted to, and I believe succeeded, in running a very robust DD process. And especially through the JRCC, and even when the Russian application issue started, all the jurisdiction put up their hand and say, we are no longer processing Russians. And to your point, the Grenada authorities discovered that while they were saying that, they were actually doing it, let's say, under the counter or behind the scenes.
Or through a back door, if you will.
Good. So when Grenada discovered that, Grenada said, we are resuming Russian applications. The then Prime Minister announced that Grenada is resuming and has resumed because of what has happened. The others say we are not doing it. So when the agreement was finally reached with the US in St. Kitts to stop the processing by March 31st, Grenada was able to credibly put his hand up and say, hey, we have a backlog and we need time to process those. Is only fair. That was accepted and agreed and was done. And by the way, I've consistently made the point between March of 2023 and late last year that Grenada is in no rush to rush through the Russian backlog. Why? Because the last thing we want is for anybody to put a hand up and say, hey, look at what has happened. So the DD that was exercised. So we asked, who are those Russians? We know who they are. The JRCC knows who they are. It was done with a kind of rigor because no one of us wanted to turn our TV on then or now, whatever time, to discover that there are rogue elements whose situation we ought to have known at the time of making a decision that that should not have been an approval that should have been granted. So we are very clear as far as that episode is concerned. To your point, so the race to the bottom is done. Regulatory arbitrage across the 5 jurisdictions will be put to an end eventually. And it's probably, I would say, kind of like close to an end, because if the JRCC is the central repository, if you agree that all the applicants have to go through your financial intelligence unit, if your FIU cannot clear an application unless it is cleared by JRCC, and that is agreed across the jurisdiction, and denial is supposed to be shared across the fact you have made, in my opinion, significant process. Now, I'm speaking as a technocrat. You are a politician. I have faith in the enterprise being pursued to form an independent regional regulator. I don't think it is too late. And additionally, the funding for the regional regulator is coming from the UK government. The UK government is saying, we understand the importance, the criticality of these programs in these 5 jurisdictions. We understand your quest to lower the risk profile, and here is how we can help. So I believe we are on a good path to righting the wrongs and strengthening those programs and ensuring their sustainability going forward. The numbers and how those numbers are going to be rationalized, is there going to be a regional cap and quota allocation? I don't know. Those are things for the politicians to decide. But I would just humbly suggest, Honorable Shastini, that the days, as you say, of the Wild West is over. That's how capitalism operates. Regulators show up sometimes too late. In this instance, I don't think it is too late. Let us ride the ship and put these things on an economically, financially sustainable footing.
Mr. Duncan, however, one of the issues that Mr. Shastini raised here, and I took note of it, and that has to do with taking away sort of national level CBI administration and putting it at the hands of the OECS. In other words, to not have your local country level CBI work happening with your agents and, you know, with the politicians involved and things like that, and putting it at the OECS level. I believe that's what Mr. Chastney. What are your thoughts on that? And do you think that that would resonate with any of the country level CBI programs?
Well, no, it's the first time I'm hearing that idea, so I will reserve my feedback on it. Just that to say, I've heard within certain circles as well, where people were saying, hey, when these applicants come through, you should only be considering them if they already have a visa to enter the UK or the Schengen area. And I'm saying, if that is accepted, it means that you, the UK authorities or the European authorities, are the ones making a decision for us. And who say every high net worth individual in the world who wants to become an economic citizen by investment in these islands necessarily want to have access to the Schengen region. That's an assumption that we make, and I always refute it to say that sent kids since 1984 had a successful program when there was no Schengen area. So again, we have to be careful how we absorb the implications of some of these ideas and some of these suggestions. So again, I reserve on whether or not a regional regulator plus a regional administrator, for want of a better word, is the solution. I do not know, but I know for sure that if these programs are to be successfully or if to be sustained, then an independent regional regulator is a sine qua non necessary for that sustainability.
Mr. Chastney, is there anything you want to piggyback on to what Mr. Duncan just articulated?
Sure. As he's indicated, since kids started this program back in the 80s, I think Dominica came on in the early 90s, and then Antigua, St. Lucia, or Grenada and St. Lucia. So we've had, 3 decades or more of a laboratory, if you want to call it that. And once it has remained in the hands of the individual countries that are selling the same product. So it's having the same product and having multiple of options of buying that same product. Like in the free marketplace, the capital market, in order to get an advantage, people cut corners. They add something here, they take a risk here, and that's exactly what we've seen in this instance. Is the regulator going to, what is the regulator going to regulate? Is it only the security part of it? The background checks? Are they going to be regulating the source of money? Are they going to be regulating the laws in each of the countries? So for instance, let me use St. Lucia as an example. Recently, contracts between a company called Galaxy, which is a Chinese company, doing a hotel development here in St. Lucia. For full transparency, my government was the one that brought Galaxy to St. Lucia. And we signed a contract in 2018. That contract was amended in 2022 when the new government came in. So you had a hotel that was going to be worth $300 million. My government gave them $210 million of files to sell as a contribution towards the development of that hotel. The new government came in and increased it from $210 million to $1 billion US. And there was no fundamental change to the size of the project. In addition to that, the company who was a developer, and Mr. Morgan would understand this, what I'm going to be saying, was also made a promoter. So in addition to being able to sell the 210 million and now $1 billion US worth of passports, they were given a commission which was equivalent to the administrative fee to the government, which came to another 150 million US. So it means on the hotel development side of it, the government of St. Lucia, the people of St. Lucia got nothing. Nothing. Is the regulator now going to get involved in national events? Are now countries going to have to now make public to this regulator all the contracts that they're signing with these individual developers, particularly when it's a hotel development or some kind of infrastructural development that's going to be taking place? I don't know the answer to those questions. But I know that there's a lot of loopholes in this issue. We've not even begun to talk about, and Mr. Morgan knows about it, is all the middlemen, the promoters, and then the next level, which is the marketing people, are all those individual contracts now going to be exposed through the regulator in order to make sure that we're selling the same product at the same price with the same standards. And I'm saying to you, sir, I don't know in the history of the OACS that we have shown that level of discipline to do any of those things. My urgency on this matter is obviously the impact it's having on individual citizens in countries and us as a region and our reputation and our banking integrity. And all those things seem to have been lost in the wayside as to what's the fallout of what's taking place. This is very serious. Now, if we really want the Citizenship by Investment program to benefit all of us, by allowing the OACS Secretariat to be the one CIP unit, so we now have one single set of rules, one set of application processes, and imagine, if you can, that the money now is going into a central fund which belongs to the OACS, whether you want to redistribute it on a per population basis, a per capita GDP basis, however you want to be able to do that, you can, but there will be full transparency of how all the money is being spent. And that has not been the common practice in our region. And I think that when you see what the Trump administration is doing right now and the seriousness of which the Western countries are taking their own borders, it is even more imperative that we strengthen our borders to give them the confidence of what we're going to be doing. Otherwise, we're all going to be in trouble, and there's going to be further fallout based on people's trust of this region when it comes to national security, which not only includes the reputation of individuals, but of our banking system.
Okay, so
Mr. Duncan.
Yes, please. So
I'm so sorry. I keep saying Morgan. I really apologize, Mr. Duncan.
Yeah, I was about to
My
say it's
apologies.
Mr. Duncan,
Sorry
not
about that,
Morgan.
sir.
Yes.
No, that's okay. I probably look like a Morgan from St. Lucia, but that's okay. That's okay.
My sincere apologies,
okay,
sir.
that's okay.
Yes.
So right. So you do not know what the regulator would do, and my point is that you will have an opportunity to influence what the regulator will do. So even if you come with a central OECS setup, you still need somebody to regulate and to oversight that. Because I have a simple principle: he who participates cannot regulate. So the OECS setup cannot regulate itself. So you still need an independent regulator oversighting, setting the standards, monitoring compliance and stuff like that. So what it is they regulate, I think when the consultation and the draft legislation is afoot, people like yourself will get a chance to chime in and to influence and to make sure. Because again, if there's not what I like to call accepted public policy position on these things. And what do I mean by accepted public policy? That across political lines is accepted. You have a problem, right? So because one party agree on this principle, the next one disagrees. So when the government changes, these things don't make sense. So let us debate, have accepted public policy stance in terms of the independent regulator to regulate the industry, and you are correct. The industry, which would include your marketing agents, your local agents, your due diligence providers, how GRCC would segue into that, and you give them the powers, okay, to set the standards, to monitor the surveillance and stuff like that. So I'm very hopeful that if we get past that, it would be a game changer. Are there further reforms down the road? Of course, there'll be further reforms down the road. And I think that what we have to do at this juncture is to say, based on what is palatable at this point, and I think all our development partners, the EU, the UK, the US, right, the OECD, FATF, right, are at one mind that an independent regulator at this point is critical to lowering the risk profile of these programs, helping to reduce the potential risk to their respective jurisdiction, whether it's money laundering, terrorist financing, access to the financial system, border security and stuff like that. So I think we are getting there, but it has to be methodical and it has to be systematic. So I will just end on that note to say that there will be an opportunity for people like yourself, Mr. Sashini, I hope, to influence and to help shape what that regulatory mechanism looks like.
No, and speaking of regulation, Mr. Duncan, and that is what we essentially decided to produce this program about. And that sort of raised my eyebrows because when I hear citizenship by invitation, in other words, based on what is described, the government will be identifying high net worth individuals through two third-party, I'm not sure if they're wealth management agencies. It all seems to be very subjective, opaque, open-ended. You know, if I may go to what it says in your press release, I believe it identifies a capital group, but essentially the point I'm making here is why, first and foremost, why is there a need for a citizenship by invitation program? And how would that citizenship by invitation program be different from what currently exists? What about the current model that you saw that you say, you know what, we actually need to do something else? Or what is the current model not doing that this citizenship by invitation program intends to do?
Okay, so thanks for that, Kellon. I like to call it citizenship by investment by invitation. So it is an initiative. Citizenship by investment by invitation. The key part of that initiative is the marketing agent called Arthur Capital. That's an already approved marketing agent under our CBI program. They already market Grenada program. They already bring applications to the Grenada program. So they are not new. What they have done is to team up with the Forbes group. And if you know, Forbes is a reputable business, banking, IT, information technology magazine that is highly reputable. So they use that brand and they produce several credible publications, specialist publication apart from the magazine. So we might have the Forbes 400 list, right, of the top 400 millionaires in the US, right? They might have the billionaire list, which might be global. So what Arthur Capital has done is to say, hey, we market Grenada as we are accustomed. But here what we're going to do, we are going to do what we sometimes calls in the sales business, market segmentation. So they look for the ultra high net worth individuals, if I may use that word, or the very high net worth individuals, 30 million plus, who are on their list, and they are saying that they will market the Grenada program to those folks on that list, as well as market to the general public as they are accustomed doing. So that's not the role of the government of Grenada. That's the role of Arthur Capital. I think the other distinguishing feature that is in that initiative is the creation of the Global Citizenship Council for Grenada. So Arthur Capital would be working with Forbes, and these individuals who are high net worth, successful people in technology, in hospitality, renewable energy, whatever, they will get an opportunity to be part of what they might call a think tank with the Honorable Prime Minister once a year, I guess, to bounce ideas and so on. As we know, it is ideas that eventually rule the world, because when you have good, innovative ideas, if you are first mover or if you move in time, you can capitalize investment opportunities and your successes. So I think we need to put those two distinguishing features of that program out there. The critical point, because it is citizenship by investment by invitation, is that none of these applicants will be able to get a pass because of their net worth or because they were referred or presented by Arthur Capital. No. They have to go through the same DD process that Mr. Sasha and I just discussed. And in the Grenada case, let me take the public through it very quickly. It will happen with every single application. First of all, the bank that is receiving the funds for the application or the applicant must clear that individual before receiving the funds. None of the banks that do CBI want to risk the corresponding banking relationship. And truth be told, if a bank says that the initial application fee is not to be accepted because of the ADD process, then it is dead. Because how do we get the investment sum if we can't even get an application fee, right? It is dead. So technically, sometimes you have the bank as a line of defense playing that role, and then you have the FIU, they must go through the FIU, who in turn has to go through the JRCC, right, for the special checks. And more important, but equally important, is the independent due diligence provider, right? They have to go through the rigors like everybody else. So I just wanted to make that point. Now, I think in the press release, the word priority is also mentioned. And to me, that is where Art and Capital now, because they're marketing to these high net worth individuals on the FOB list and also doing their road shows across the globe for applicants, they are saying that they will prioritize those applications from the FOB list ahead of those that they will be receiving from the general marketing campaign. So that's where that prioritization comes in. When it reaches having gone through certain processes and so on, the Investment Migration Agency, yes, in order to be working in tandem with Art and Capital, we too, because of the segmentation, would want to ensure that it is prioritized, not even preferential treatment. You have to meet all the criteria like everybody else. Just that we are saying that where there is a queue, this is a queue for Art and Capital. It's like you go in the supermarket, Kelon. You have a priority line for people who are nursing mothers, elderly, whatever criteria the supermarket set up. But when you get to the checkout counter, the price for the laundry detergent, the vegetables, the eggs is the same price in that priority line, right? There's no pass if you're in that priority line compared to any other line. So I just wanted to make that point in terms of how in the sales industry, the service industry, you prioritize and segment your customer base. It's like maybe banking might be another good example. We have a priority line, you pay the same fees like everybody else, but because of your special circumstance, you may, get ahead of others. But the criteria...
Mr. Duncan, here is my issue. And again, I'm wearing the political economy cap here. Is this a case of the tail wagging the dog or the dog wagging the tail? May I finish the question, please?
Sure.
Was this sort of a proposal advanced by Art and Capital that the government is just going ahead with, or did the government of Grenada conceptualize this and said to Art and Capital, this is what we want you to do?
I think it was an iterative process, and one of the things that we have to appreciate very much is that the nature of any of these service industries, if you may, is one where there is evolution and there are improvements that are being made. So we have ideas of our own. I mean, we have a strategic plan for our program, right? And there are certain things that we are doing that will eventually come to market, right, or be known to the general public in time when it gets to that stage. So this is just one, right, of those initiatives. How can we, and I made a point earlier, drive, the sales of the Grenada program? And again, coming back to the Forbes list, many people believe that the millionaires who qualify for these, or who apply for these programs and so on, are not quite millionaires. People complain that they are coming from Holland, they are coming from other jurisdictions, China, Russia, and so on and so forth. And here you have Forbes list with the top 400, for example, American millionaires who they say are potential applicants for the CBI program. Who are we, in the marketplace and so on, to fail to give credence to an initiative like that? So that list that they are going to be built, if it comes off, that Forbes 400 of Americans, that changes the equation, because people would then say, well, wait. The idea of a global citizen is not just based on some Chinese, Russian, Nigerian, South African, wherever else, who wants a second citizenship. That global citizenship and global mobility transcends all the continents. So I just wanted to make that point as to we should not.
Mr. Chastanet, should you assume the government in the next election, based on what we've just described here, citizenship by invitation, is that something that your government would pursue, given everything we have been discussing this morning around your desire to have more OECS level regulations, sir?
So again, my government would work with the other heads to try to convince them, because we can't force them to have a singular entity. And the importance of the single entity, and I agree with Mr. Duncan, they still have to be regulated, but the reality is because it's one entity and it's one set of prices, one set of applications, some of the nonsense that we've seen been going on would be eliminated. So we would really work very hard to convince the governments to go in that direction. If in fact that the governments don't want to go in that direction, then St. Lucia is going to have to give serious consideration as to whether it wants to remain as a signatory to the Bastille Treaty to allow other OECS citizens who are CIP citizens to be able to come into St. Lucia and benefit as other OECS citizens do. Now, I can say to you that that would open up a Pandora's box, because it would, for the first time, segment what are natural citizens and CIP citizens. So, person you were speaking about earlier today, Prime Minister Gonzalez, has refused to be part of this program, and in his own mind believes that he's already made that segmentation. Although lawyers from CARICOM have indicated to him, no, that a CIP citizen, as we speak today, benefits from the same things as other citizens. You see, this brings up a very big issue, because you can't have one without the other. I also believe the direction that Grenada is attempting to go into may be the way we're going to. There are claims right now that because of the instability in the West, what we've seen taking place in the UK, in the US, and other countries, that there are high net worth individuals who are looking for alternative places. But there's a lot of competition in the world for those persons. And anything that we do, whether it's the high net worth individuals, whether it's the middle income persons or low income persons, as a salesperson, there always has to be a hook. What's ultimately going to cost? Is it price? Is it benefits? What are those benefits going to be that we're going to produce? And all of this discussions that we've been having, to be honest with you, and with what's taking place in the US right now with immigration, brings back very much into focus what the focus of the OECS should have been and must be, is raising the standard of living of our region and making ourselves competitive. People hate to hear the comparison, but the story of Singapore and what Singapore did to transform itself from a third world country to where it is today, we may not be able to achieve it on the same scale, but we certainly have to try to achieve it in the same standard. Do we have a healthcare system that people internationally find support in? Do we have an education system that's international? Do we have proper telecommunication systems? Do we have the ability of being able to fly in and out to multiple destinations from our own destinations? Now, in order for Grenada, if I can use Grenada as an example, but the same thing applies to St. Lucia, there needs to be a minimum number of investment. Your GDP has to be a particular size in order to be able to provide that. So growth of our region is paramount to our own success. And so the citizenships that we're going to be going after now, which are not going to be price driven and are not going to be deal driven, but in essence now are supposed to be adding fair value in a transparent way, becomes much more difficult. And I would just say to Mr. Duncan, Forbes and The Economist and other magazines offer what's called advertorials. I certainly hope that that's not the direction you're going in, because if it's an advertorial, it's really not Forbes magazine. It's a third-party entity that's buying advertising space in it, and it will be, the disclaimer will be there. I'm not so sure that I find any credible source that would say to me that Forbes is going to give you or anybody or sell access to their top list of billionaires in America. So I would just say to you, I know you from the sounds of it, you're a very diligent gentleman, and it sounds like you're doing a great job. But just be very careful with that. That's not what you're buying into.
Well,
there's no need for comment. There's no allegation or anything. I'm just saying, as my own experience, I literally on a quarterly basis as Prime Minister, you have these people coming in presenting that they represent Time Magazine and they're going to do this big feature. But all in all, it was an advertorial which required advertising on our part, etc. Obviously, CIP and Arton are very skilled at those things. So just be careful with that.
No, thanks for the counsel. I mean, well taken, and it will be borne in mind all the time. I mean, I've seen it over the years as well, what you have just mentioned. But from the analysis that we have done so far, as well as due diligence, I think that we are on a relatively solid path of what you might want to call market segmentation as far as that is concerned. So, as we like to say, watch that space, right? We will do our very best to make sure that it is an initiative that succeeds and that others could learn from, going forward.
And gentlemen, this is such a robust conversation today, and I'm so glad I was able to get both of you together. And before we get to closing comments, we will also get to some viewer comments. And again, I'm wearing this political economy hat here, and speaking of influences with money and politics. I mean, we see that playing out in the United States, and here we are talking about attracting high net worth individuals. I mean, that's what the CBI program goes after. It goes after high net worth individuals, and so this is the concern that I've always had. In the absence of campaign and political finance legislation in the Caribbean, there absolutely is no law that would indicate to someone, at least I can speak for the OECS, I can't speak for the rest of the Caribbean, how much can someone contribute to a particular political party? Last year alone, we have attracted thousands, in the case of Grenada, high net individuals, from the Russian applicant, the backlog, we dealt with that, as well as folks from Nigeria and China and so on. Who is to say that these people at some point will not want to put their fingers on the scales of local electoral politics by using their net worth to dictate what happens at a policy level in the context of Grenada and, of course, St. Lucia as well. And we have another question here from a viewer who is saying, can CIP citizens register to vote in general elections in Grenada? I believe they can. They are full citizens, yes? So that's just my bone of contention here, Mr. Duncan. And I'll get you to chime in as well, Mr. Chastney.
Okay, so on the first part, not being a politician, I will defer to Honorable Alan Chastney on the first part, which is political campaign financing, right? As a technocrat now and the chair of the CBI, what we do is as per prescribed in law. Okay, we are entitled to run the program so that when applications come in, based on all available information that we spoke about this morning, in terms of where we get it from, the GRCC, whoever, and so on, we make a recommendation to the cabinet to grant or to not grant citizenship. Once that is done, our role for all intents and purposes is over as far as a citizen of Grenada is concerned. That's done by Home Affairs, what they're entitled to in terms of passport and everything else. That is outside our jurisdiction. We will, however, because of where we situate, facilitate if there's an issue, there's a snag, there's a delay, and so on, they'll want to come to us. We try to segue to the relevant authorities to make sure it happens. But we do not have any jurisdictional or administrative, control over it. In terms of the point that you raised, I've repeated continuously, the law is very clear. Grenada has one class of citizen, not two, not three. If you're a citizen of Grenada by birth, you're a citizen of Grenada by descent, you're a citizen of Grenada by investment, you have the same rights. There's one class of citizens in Grenada as far as I am aware, legally and practically. So I just rest my case here, and I guess Honorable Chastney, being a politician he is, can speak to tail skipping and campaign financing.
I'll try to take
Mr. Chastney, go ahead, sir.
I'll try to take the designation as being a politician as a compliment and not as.
No, it is. No, it is.
Look, I think that these are all very, very interesting questions. Investment has always, whether it's been attached to citizenship or not, has brought into very strong focus campaign financing. And it's long overdue to have a very serious discussion. I would say to you, without fear of contradiction, the vast majority of funds coming in to fund campaigns in the OECS come from outside. I would probably say as much as 80% comes from outside. And nobody knows who those persons who are making those investment or those making those donations are. And I think if there's one thing that this show ought to bring into sharper focus to your audience, is there are a lot of decisions and a lot of things that are being done under the CIP program that have significant implications to all of us. And we, for some reason, have not connected the dots. And I'm hoping if there's one thing that your audience gets out of the show today, is that the source of money, the money going through the banking system and the impacts it has on correspondent banking, who these individuals are. And if I was to say to you that within the OECS, so between St. Kitts, Dominica, Antigua, St. Lucia, and Grenada, since the inception of this program, we're talking probably close to 300,000 new citizens. Okay, 300,000 that are now citizens within the OECS, who all can individually vote in their own countries, but can also now migrate and be treated as citizens in the other OECS countries. And I think it's gotten to the point where we all believed that what Mr. Duncan described today as to the due diligence and all the stuff that was taking place, we all assumed all along that that's what was taking place. And I'm going only back to 2016 to tell you that JRCC, that wasn't happening. Absolutely was not happening. So how many of those persons who have been approved, and how many stories have we heard recently of persons with passports from Dominica or passports from St. Kitts who have been involved in significant crimes in the Western world? When St. Kitts lost its Canadian visa, it was because the government of St. Kitts not only was issuing CIP passports, but was also bestowing diplomatic status on many of those persons as well. And as a result of what happened in St. Kitts, eventually the Canadians went to what's called a visa waiver process. Now, I know my friends in the Western world are not going to be happy when I say this, but the visa waiver is a geopolitically correct way of taking away our visa-free access. Because none of us know what the logarithm is in our application to get our visa waiver. We don't know. They can simply say any Grenadian who was not born in Grenada that's making an application for a visa waiver to go to England, because that's now implemented, right, will be denied. And what's the purpose of the denial? Is to achieve exactly what Mr. Duncan spoke about earlier, where they're saying we should only approve CIP citizens that have visas to go to the US or Canada. So if in fact a person who is Egyptian, who has a Grenadian passport, is denied their visa waiver to go to England, they have to now come to Barbados to apply for their visa. They can't go to the British Embassy in Cairo and make that application. So it's forcing that individual anyway to have to go through the Western border to be able to get in there. So they're doing what they have to do to protect us. But in the meanwhile, our national citizens have lost a benefit, a significant benefit that I don't think that we're ever going to get back. And so these are some of the consequences of the decisions that we're making, that there isn't sufficient due diligence or checks and balances. So an entity that you and I all would have expected to be much more vigilant about what's taking place in the CIP is our bar associations. But here in St. Lucia, by going from 800 applications to 11,000, and on the 11,000, the local agents, which are the law firms here, get on average 5,000 EC dollars per application. So in a matter of 2 years, the law fraternity here has made $55 million. Now, I'm not telling you that that's why the Bar Association has been quiet, but it's fair to ask the question, right? So a significant checks and balances, particularly on the legal aspect of it. And you know, what is egregious for me, we're in the process of filing a judicial review case, hopefully tomorrow, on the CIP program. One on misfeasance. Is it reasonable that the government would have given away so many passports and given away our administrative fees? Is it reasonable that a contract was signed by the Minister of CIP for financial agreement? Those are matters that the law is going to have to pertain. But the same question must have been asked by the lawyers who were actually processing the applications as agents. So there's a famous saying that I would say to you, Mr. Duncan, that I've heard I read it in a book, Cotton Club. And it said, those were words spoken like an angel, too bad we live on earth. And I've embraced those things because sadly, we are our own worst enemy. And if ultimately at the end of the day, it was to have used CIP to benefit the citizenry of our country to maximum and not to hurt it, I think that we have failed. And I think it is time for us to seriously review the lack of checks and balances. I mean, I'm disappointed in the central bank, and I've said that to the governor, that it's taken them this long to have gotten involved. But when you have a central bank where the board of directors of the central bank are the ministers of finance, I challenge you to find out where else in the world that exists. The central bank has to be independent. The poor governor's hands are tied. And CIP has significant implications to our currency and the integrity of our banking system. And I think that they've been absent from their role. I mean, they're getting involved now. I still think it's moving way too slow. And I certainly, what I'm saying here today is nothing that I have not said to the governor himself. He's a person I have a tremendous amount of respect for. But I just feel that we're not taking this thing as serious as we ought to. It has significant implications, and the evidence is there. Once there was a free-for-all, and everybody was finding ways to cut corners, the numbers of sales went up significantly. And when you get that volume of business, then the due diligence becomes much, much more difficult.
Gentlemen, yes,
Kellan,
Mr. Duncan, go ahead.
Yes, just to say that on the question of the 40-year history, right? So sometimes I've argued, guys, you have 40 years of history. You're supposed to have 40 years of data. Let us do the statistics. Poll to see how many applicants, citizens have been approved by each jurisdiction, and what percentage of that turned up on the shores of the UK, the EU, and have committed egregious crimes and blah, 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 blah. And that was the real risk. Let's measure it, right? Now, I'm saying that would help us now to determine, hey, the individuals who have gotten them or who are involved in crimes having become citizens of this jurisdiction came primarily from this region of Russia or this region of China or this region of Nigeria, or the marketing agents who brought these to market, right, are only 2 or 3, such marketing agents. So therefore, we can better calibrate our intervention to improve the program. So, for example, as you are aware, I mentioned Dominica, they have revoked a number of citizens' citizenship in recent times. So it appears as though the data, once it comes available, people are prepared to act. Now, my point is very simple. If at the time of granting approval, information was available that I should have gotten that would have resulted in a denial, and I did not get that information, it means the system has failed. That's on me and my DD providers and GRCC. If, however, subsequent to granting the approval, the person commits an act or acts. That cannot be on me because nobody is aiming to predict human behavior. That's not the model. The model is DD is based on connections, past activities, and stuff like that. So I'm just saying, to your point, Mr. Sashini, that the need for research, and that's something that we don't do, right? In fact, the literature on CBI coming out of London School of Economics, right? In terms of one of the most recent books that I've seen and so forth. And then you have the Investment Migration Council and so on, all again, Eurocentric, and putting these things out. And by the way, CBI, investment migration, being a global phenomenon. Turkey alone has half the world business. Turkey has half the world business. So we here in the 5 OECS country probably are less than 10% or 5%. It's a fraction. So to your point, Mr. Shastini, doing a better job, getting a bigger market share, and at the same time lowering the risk profile and addressing the concerns of our development partners are critical for our long-run sustainability and viability. Why should Turkey have 50% of the market, right? So I'm just saying there's a lot of room for improvement, no doubt. I agree with you fully. The question is, let us agree on what is feasible. And because the EU, the US, OECD, FATF, right, are talking to us, FATF has released a paper last year, which we are studying and looking to see how we can take improvement initiatives to allay their fears. It's good because if we go into point A and there are 3 people talking to us, it makes no sense we take in 3 different vehicles to get to point A. If we all could go in one vehicle, that would be nice. So the US initiated it. The Europeans are on board. The UK is on board. So by talking around the table periodically, right, twice a year sometimes, we will get there. That's my belief, and I think that's our hope, that collaboratively we lower the risk profile, we improve these programs, and to your point, for the betterment of the citizens of the OECS. The shenanigans that have gone down, or maybe are going down, I agree they need to be dealt with. Knock on wood, we here in Grenada seem to have escaped so far, right, what some other islands have gone through, but that is not to say that we are not without our issues. In fact, we investigate things from time to time. We argue that he who asserts must prove. So when people come with allegations and so on, we ask them to get evidence. We go after it. We try to ride the ship. It's continuous work, ongoing work, but all the good work for the betterment of the people.
If I can just say one thing, very quickly. Our history has a fact that it's not until we're caught and pressure is put on us that we come to the table.
True.
So let us understand why everybody went and met with the Americans and the British at that time, because they had been asking for that meeting for the longest time. It's when the visa revocation came of Dominicans, and which was then followed by Ireland, that basically don't even allow them to apply for a visa waiver, that all of a sudden people started going, okay, this is getting serious now. And we all understand the implications to all of us. I'm just hoping that this lull, and that's what it is, that we're going through, has not in any way tempered the urgency that exists. And sometimes it's the silent killer. And right now, it is very clear that the US, the Europeans, and everyone else are taking their borders very seriously. And so CIP has been around for a long time. We're not the inventors of CIP, so I absolutely agree with that. But we are small countries with very little political weight in the international market. And this is something that I honestly believe can benefit all of us. So I'm not here in any way advocating against the CIP. What I'm advocating against is the lack of transparency, the lack of a consistent policy program. And the fact is that whenever there have been cases of persons who've been caught, generally speaking, they are persons who came through the back door. And so that's the problem. How is it that we have a program that would allow the politicians to involve themselves? And that is what we need to satisfy and ensure all our citizens is not taking place.
It's so much to unpack, and of course, and speaking of politicians satisfying themselves, Mr. Duncan, one of the questions I had, which I will state publicly, but I'm sure you may not have time to respond to it, and that has to do with the presence of the Prime Minister's personal assistant on the CBI board. That is a concern that has been raised in Grenada as well in some circles, and again, in respect of conflict of interest issues, how do you minimize conflict of interest? Especially when it comes to CIP decision making. But
Colin, let me chime in one time. I mean, you
yes.
may be aware that I have been an advocate of several things when it comes to these institutions and the question of governance and the question of making sure that these boards and these committees have a good mix of mature people, young emerging professionals, right, who are trained and trainable. And by virtue of your employment, I don't think you should be denied an opportunity. So yes, she's a prime minister.
Not even if you're employed in the Prime Minister's office, sir.
Not at all, because what would that do if the person is and the other point, we make sure that every director is or goes through a process of acquiring a body of knowledge to become an accredited director. So you're not just there, you are trained and you're accredited as a director. The entity on which you serve ought to have a charter, they have rules by which they abide and decision making takes place and so on. So I'm very comfortable that the young lady in question, that is committee member Leslie now, has to grow and emerge as a well-rounded director, right? So what would she do? She would make a decision or the committee would make a decision, and before the meeting ends, she will go back and tell the Prime Minister. What would she do, right? The Prime Minister would tell her, you're going to meeting today, so go and say X, Y, Z, ABC. That's not how it is done, at least not under my watch as chair of the CBI. So that does not give me any pause at all. In fact, I think it is a good thing that you have someone who can grow and emerge, to my mind, eventually a formidable director. Now, at the same time, I'm not blinded by the fact. She's not conflicted, there's no doubt about that, but I'm not blinded by the fact that she could be placed based on certain debates and discussion and what people utter in a sort of an uncomfortable situation. That is possible because of her proximity to the thing, but I'm advisor to the Minister of Finance and I'm chair of the CBI. So what are you saying? I'm conflicted? Of course I'm conflicted. The question is, how do you manage the conflict? Do you understand?
Okay,
fair. Conflicts of responsibility and conflicts of roles must be managed. That's all. Yeah.
On that note, gentlemen, we have to, yes, Mr. Chastanet, in closing comments, I want you to make the point you're about to make, sir. And you can offer closing comments as well.
Thank you. Obviously, I've been involved in a lot of different court cases, constitutional on top of that, whether it's been the boundaries, whether it's been my expulsion, my attempted expulsion from Parliament. I have a situation where a judge recused himself from 4 of my cases, and then was transferred. And here we are a year and a half later, and I have no judges assigned to my cases, judicial reviews, etc. And in all of them, the former Chief Justice had indicated that when people are put on a board, regardless of what their political affiliation is, they are to derobe themselves of any associations and are to act independently. Unfortunately, cynicism exists in our region, and we don't believe that people can do that. So it doesn't mean that everybody, regardless of how quiet they are about it, don't have some kind of political bias. But certainly when you put persons directly in the line of fire and really have to test that ability to derobe themselves, I think ultimately we will be much better when we recognize that public opinion matters. And it's the public's business that we're doing, and the public must be satisfied or felt comforted that we can do that. So I would only say that to you, Mr. Duncan, that There are a lot of people that can go on these boards. You know, should somebody be coming from the Prime Minister's office, especially, is the Prime Minister the Minister of CIP in your country?
Yes, he is.
Yeah. So, you know, ultimately, it's like even when in my instance, because I was also the Minister of CIP, when it came to persons who wanted to, ask for a review of a decision, I chose not to do it. I chose to put an independent committee, and I put persons who were not involved in the CIP program to be involved in making that final decision. Whether people believe me or not, that's always an issue. But CIP is a very difficult and very ticklish issue. I think that we have failed in getting the public to really appreciate what we're doing and the sacrifices that we're making, because this is not free money. By any stretch of the imagination, this is not free money. And so not only in how the persons were approved, but what the money is being used for, because we've spent no time on this show, and that's not your fault, following the money. Where has all this money gone to? How much money should we have? And where is that money being used? You know, I inherited a program. I regret that I didn't make further and stronger amendments to it. I tried to. This idea of hoteliers coming down and using our CIP funds to build their hotel. I think that we should have gone to a program where our investment agencies should have been allowed to be a CIP agent, and that they could have gone out and sold CIP to build hotels that would have been owned by the state. And then we could have leased those hotels out exactly how some of these individuals are doing on that case. So I think there is time still for us to really dig deeper, a deeper dive into the whole robustness of this CIP program. Understand there like everything in life, there's a cost benefit analysis that needs to be done, and what the potential costs are, because I don't think we've exhausted the full extent of the cost, nor have we looked at the full ramifications of the benefits that we ought to be getting, the potential of the benefit. Are we achieving that potential? We speak of big numbers and everybody hears this, but how much money actually ends up in the coffers of the state is still very questionable. Certainly in the case of the context of St. Lucia, I will not pass comment on any other country and when it comes to that. So I want to thank you very much for the opportunity of having this discussion, and even the one that you had earlier today. I think that we're a young region when it comes to our own independence. We're still learning the real issues of our constitution, of our own rights, and how we are to interact. And one thing that came across on both segments today is checks and balances. Your constitution and your democracy is only as good as the checks and balances we have, and that when persons who are supposed to be in authority or being appointed to boards are there to represent the people and they don't do it, there is not a hard enough consequence to that. We're not taking that seriously enough to make sure that our democracy is stayed. I mean, I use the example of South Korea when the president attempted to impose martial law. It was that same day that thousands of South Koreans appeared at the parliament, surrounded the parliament, and did not leave until a vote of no confidence was passed, and ultimately the president was ejected, simply on his attempt to impose martial law. To do what? To pass bills that he was having difficulty in passing. But that's the level of understanding I'm hoping that we will get to one day, and that's the level of seriousness that I am hoping that we will take our own constitution and our own democracies.
Absolutely. Mr. Duncan.
Yes,
closing
sir.
Comments, sir.
So closing words, just let me agree that when you get appointed to a board or committee, you have one mandate, and that is to look after the affairs and the well-being of that entity on which you sit as a director or committee member. And ultimately it redounds to, again, the best benefit for the public and so on. So that is settled in terms of corporate governance among us. In terms of where the money goes, if you look at Grenada's Article 4 consultation report, one of the comments they made about data and information is they applauded the availability of publicly available information on the IMA website and on the Ministry of Finance website. And it's not just under my chairmanship even before, right? It is right there for everybody to see. Number of citizens year to date for this month, aggregating for the quarter. You have a comparative analysis, you have graphs and so on and so forth. It is there in the public domain, and we have been applauded for that. In terms of where the money goes, that is extremely important, and we have again published the numbers in the Ministry of Finance. And one of the things that I think the ministry should be proud of, and the government, is that since 2023 it began putting aside real money at the ECCB for our contingency fund. Previously, the law says 40% must go into this contingency fund, not a black cent went in, and that is since 2014. From 2022, it was reduced to 10%, and it has been lodged at the ECCB to the aggregated total now of $54.6 million EC. Contingency fund, a buffer fund. So even Hurricane Beryl was not a sufficient disruption to draw down on that money. It has to be major economic shock. So that's one thing that I want to highlight. I also want to highlight the fact that we have, at the IMA, CBI, done at least 4 public symposia between 2022 and now, to Mr. Sachinet's point, explaining for the public what we do, how we do it, and why it is important. So the demystification of CBI has been a major thrust of ours, and whenever we survey participants, by and large, 70% and up say that they are a little bit more enlightened and a bit more appreciative of the program. And I think the other thing that we do at the level of the committee and agency is that once a year, we go and do a field visit of those projects, not just to see what is going on, because we are not all engineers and quantity surveyors. The staff, do those things throughout the year, but to show some appreciation to developers themselves, let them know at the highest level that we are watching. And what we did this year, this December, was to embed the media on that tour. So they were there to see for themselves and to ask questions as to what is going on with these projects. So again, I just want to say that it has been a good session. We continue to work.
We always try to have good sessions here, sir.
Yes, sir. Yes, sir.
I'm glad you enjoyed them.
Mr. Sassin and I met, but you would not recall, I think it was at the repast that we had that was held for Sir K. Dwight Venner when he died back then. So, so again, it has been a pleasure, right? And let's continue dialogue and continue the quest to make the region.
Yes, and for us here, it's all about public education and working through those issues in a way that would empower our audience with the knowledge that they need to make sense of those issues. Because sometimes a lot of those issues are so technical, and the reason why we try to bring panelists like yourself here is to distill and simplify a lot of those technicalities and to speak to those implications. So thank you, gentlemen. Absolutely. Thank you. Thank you for appearing on the Bub Report this week. Viewers and listeners, this has been yet another edition of the Bub Report. For the last segment of our program, we were joined by, of course, Mr. Alan Chastanet, who is the leader of the opposition in St. Lucia, as well as the political leader of the United Workers' Party, and Mr. Richard Duncan OBE, who is the chairman of the Grenada Citizenship by Investment Committee, speaking to the implications of the Grenada Citizenship by Invitation program, as well as other regulatory issues that relates to what the future of CBI would look like for the region, and of course other issues related to CBI that was raised. And earlier we addressed the vaccine mandate case over there in St Vincent and the Grenadines, with the aggrieved parties losing the appeal that was brought by the government of St. Vincent and the Grenadines to appeal the judgment that was initially ruled in the favor of the affected, dismissed public servants in St. Vincent and the Grenadines. So viewers and listeners, again, thank you for tuning in to this week's edition of the Bub Report. As always, audience, we thank you for your participation. Again, given the depth of some of these programs, sometimes it's difficult to get to viewer questions, but we certainly thank you for posing those questions. And of course, Brenda Lee, good day to you. You're saying thank you, Dr. Bub and panel. Great program shared today. Sonia Lessie, hello Sonia, it's good to see you. Great program as always, as well as Ingrid Byrne sharing the same sentiment. So thank you all for your participation, and we will see you next week for another installment of the Bub Report. Take care. Bye-bye. Hi everyone. Thanks for checking out the Bub Report's social media pages. If you'd like to get more videos, show highlights, and watch our weekly live show, follow our Facebook, Twitter, and Instagram pages, and also subscribe to our YouTube channel. You can catch repeat episodes on Wednesdays at 4 and 5 p.m. respectively on CRFM Radio and GBN TV in Grenada. We are also viewed on Sundays at 8 p.m. on WPG 10 throughout the Caribbean. Thanks for watching.